So this is the second segment of our discussion of science and environmental law. In this segment, I want to dig a little deeper on the issues, multiple legal cases surrounding the Deepwater Horizon oil spill that took place back in 2010. And mainly because I, for one of the first times in my career, had in-depth engagement in various aspects of it. And I have a lot of personal experiences to share with you as a result of that. So there are a number of components of the legal process and the court issues related to the Deepwater Horizon oil spill. And one dealt with issues related to the criminal law violations. These were felonies in some cases that were committed, and that the Department of Justice went to prosecute BP, the company, for those felonies and violations, and for which they were criminally liable. And that never came to court, but it resulted in an agreement, a settlement, before it went to court, of those criminal charges, in which BP agreed to pay $4.5 billion in fines and in payments, including $2.4 billion to the National Fish and Wildlife Foundation for environmental restoration projects throughout the Gulf region, and $350 million that added to another $150 million from a settlement with Transocean, the operator of the drilling rig, that's gone into a trust fund for the National Academy of Science to support science related to the long-term issues of the Gulf of Mexico. So the part that went to the Fish and Wildlife Foundation, actually, I was told, resulted from some consultation that I had with the criminal division lawyers about possible remedies with respect to environmental restoration projects that they could consider on the criminal side, on the civil lawsuit side. And so I got to brief the criminal prosecution, and they liked the idea of having had BP pay us some significant amount of money for environmental restoration. It had to go to a non-governmental entity, so it was directed through the National Fish and Wildlife Foundation. So I don't know, there are multiple factors in that, but I feel pretty good that that consultation had some role in that determination. Clean Water Act violations. There are requirements under the law that if you're responsible for spilling oil, you have to pay so much per barrel of oil as a fine, as a penalty. And so the question was to bring this to a civil trial. And there was, again, efforts to try to settle it in advance, and they failed. But so it actually went to trial on February of 2015. And was the only real case where evidence was presented on these matters in a court. The settlement for that, a judge didn't ultimately rule on it. The judge was very anxious in having the parties settle it, so he didn't have to rule and have a ruling that could be appealed and potentially overturned. So the settlement resulted in a $5.5 billion in criminal penalties, together with, and that was settled together with the last issue, which is the natural resources damage assessment. Remember, this is Clean Water Act, under the Clean Water Act, and this is under OPA 90, the Oil Pollution Act of 1990. And so as a result of that, they rolled those together and made a settlement of the whole package. This process involves the natural resources trustees from the federal agencies as well as the states and the responsible party coming to that agreement. And this was a result of a detailed assessment that had been underway to assess the nature of the damage, to quantify them. And it was terminated basically when the settlement took place in July of 2015. And that settlement brought up to $8.8 billion for restoration and recovery under the natural resources damages. Clean Water Act trial is the only one that actually went, as I said, was heard in court. The details evidence was heard in court. So the Clean Water Act sets a penalty of $1,000 a barrel of oil released but it could be up to $4,300 a barrel, depending on the degree of gross negligence. The phase one of the trial was to adjudicate responsibility and negligence. And the judge listened to the evidence and apportioned the responsibility among BP, most of it going to BP, with some going to Transocean. Much lesser amount operated the drilling rig. Halliburton was involved in the cementing of the well. They got a small area of liability. But also, the judge ruled that BP was grossly negligent, and thus subject to this higher fine. The phase two of the trial really tried to address the question of how much oil was released. You know, if you have a fine per barrel, you have to determine how many barrels. And the U.S. argued that it was 4.2 billion barrels, and BP argued that it was only 2.4 billion barrels. And the judge heard lots of complex information, basically said, I'm not an expert, it's hard for me to judge these things, and basically split the difference. And this resulted in setting the maximum possible fine at $13.7 billion. Now, that wasn't, the judge was never going to fine them that much. That was pretty clear. That would be, break all records by far. It's a huge fine, a huge precedent. So the phase three part of the trial is that under the law, the judge can hear arguments on the factors, mitigating factors that the court can consider, eight other factors. And they include things like the financial, economic impact on the region, but also the seriousness of the violation, the harm that was done to the environment, as well as the success in minimizing the effects. That BP do everything possible. And it was pretty clear from the evidence presented and the judge's attitude that that BP had been shown to have gone overboard, opened its wallet and spent lots of money to try to minimize the effects. So this seriousness of the violation became one of the central issues, and this is the part which I testified in court. So why was this such a big stake? Why was this such a big issue? As we went to court, mind you, this was the part that we were trying to determine what the civil penalties were. Already through a law passed by Congress that would go to a trust fund, which would fund restoration projects, environmental restoration projects throughout the Gulf, some portion of it anyway. And the criminal penalty part had already been determined. This was a big unknown, but what was clear is that how much this was to determine what that ceiling would be, the 13.7 billion, and give the parties some sense of where the judge might be in that range. In some things, he was prepared to give BP a lot of credit for, but others, like the seriousness of harm, less so, as it turns out. So this was the only litigation for which evidence was presented in court, as I indicated. It really set the upper limit of what the Clean Water Act penalties were likely to be. The court and it also revealed that the court was likely convinced that environmental effects were serious. I think I'd made the case in BP's argument that they were minimal. The effects were minimal. He didn't seem to be buying it. And it set the framework for a negotiation of a broader settlement among the parties, not only for the civil penalties, but also for the natural resources damages. So that global settlement was reached a few months later. So on July 2nd, they announced that the U.S. government and 5 coastal states settled the case, and including claims by 400 local governments. The Clean Water Act penalties were set at $5.4 billion, this should be, and up to $8.8 billion in natural resources damages. There's a clause that allows them to take a bit more than was set, up to $8.8 billion, depending upon the lingering damages and the like. $5.9 billion will also go to the states and local governments for the expenses that they bore and lost revenue, things of this sort, as a result of the spill. And importantly, the provision was made that this could be paid out over an 18-year period. Didn't have to be paid all at once. The judge accepted this settlement in 2016 after the release and the public review and revision of this report, this damage assessment and restoration plan. and the programmatic environmental impact statement. The judge wanted to make sure that this was publicly acceptable and had seen the light of day. This is in this report, the government presented its case for the damages, natural resources damages, but also puts together a restoration plan. And again, this is an area where I was again called in to help in this settlement. Settlement had been constructed, but I had to help in this report because the folks who were doing the damage assessment, one group of people really focused on that, and then there were others who were working on these various restoration plans, kind of walled off, and they weren't giving. It wasn't clear that a compelling case was made between the natural resources damages and the restoration plans. Natural resources damages are, species specific and, and local, and the restoration planning was more of an ecosystem restoration. So I was called in to help them hone the case for the judge and for the public on that matter. The judge, I was ready to go and testify back to the judge if he had questions about it, but the judge accepted the settlement in 2016 after this public review and the revision of the damage assessment and restoration plan. So I'd like to share with you a few things that I learned from this process of being an expert witness. I'd only appeared once before in court as a witness, and this was a much bigger deal and involved much more preparation and work. So the first thing that are done is the expert witnesses that the parties tend to call have to prepare a written report. Now, when you write this report, the primary reader, the audience, is the judge, and the judge is a layperson. So as a scientist, you have to write the report in a way the judge can understand it, use simple language, that all the things we learned about not using jargon and things of that sort are important. And as soon as we finish those reports, they're exchanged. So the BP expert and my reports, go across, and so we then had an opportunity to rebut the analysis made in our reports, and then those rebuttals are exchanged, and then there's a final response. So there's a lot of work of dealing with it, and the question is, you have to kind of disarm the arguments of the other side, but do it in a respectful way. The judge doesn't, is not going to think too kindly if you get too obnoxious or too personal in your arguments. The deposition was a grueling, more than 8 hour in a room with the cameras on you, recording the whole thing, where you're being pinged continuously by, in this case, a BP lawyer, and you have before you all of this evidence, documents that you've written or that the literature that you relied on, emails that I had exchanged that they had gotten access to, papers, even a paper that I wrote on oil spills back, it was 35 years before, all there asking questions about this. And I learned in this process that this isn't about making the case. This is about avoiding putting yourself in a position where you give them some ammunition or some information that could impeach your expertise before the court. And it's a different experience, and I learned the hard way as I went through this. The trial itself, when we went to trial, there was lots of moot preparation. In other words, I had to go through repeatedly my direct testimony, answering questions posed to me by my attorney, the Department of Justice attorney in this case, as well as through moot cross-examination, which was particularly vicious because these lawyers, even though you knew them and worked with them, they know your arguments in the case as well as you do, so they know where the holes are. And so it's to learn how to address that hostile, aggressive questioning and to do it in an effective way. I was very pleased that I'd gone through that. So what did I learn? First of all, I learned that when you agree to work with a lawyer, set on one side of the argument or another, you should agree on the objective, the scope of which your expertise is, and make sure that you're going to be able to do this with appropriate level of independence, not be coached by or have words put in your mouth or being told what to testify by the lawyers. You need to understand the limits of attorney-client protection. Only a little small amount of the information that you would exchange back and forth with the attorney is actually protected. You have to know what that is, and everything else is discoverable. You always have to be precisely truthful, not generally truthful, but when you state something very precisely, you must do it in a way that it represents the truth as you know it. You don't accept the opposing attorney's characterization of the evidence. I was asked questions like, "Wouldn't you agree that?" And I immediately said, "No, this is what I would state it as." And they tried to constrain me from saying that. The judge allowed me to answer the question my own way. But going through that process was a very tricky thing, and I'm glad for the preparation. Admit when you don't know something. There's a tendency to think, well, I'm the expert, and I don't want to show that I don't know something because it would diminish the judge's impression of my expertise. But you don't want to be evasive, or you don't want to be bullied. So admitting things that you don't know can be a very effective strategy. Organize and practice the direct testimony, like I mentioned, and then practice the cross-examination by a very knowledgeable attorney. Again, it's not fun when you're doing it, but it pays off in the long run. And remember that when you speak in court, you're really speaking to the judge. You're facing your own attorney in the direct examination and the defense attorney in the cross-examination, but that the person you're really speaking to is the judge. And so I was taught and was able to, with the attorneys right directly in front of me, kind of turn and look to the bench when I'm speaking and speak to the judge. And that was very effective because I knew I could get in a sense from his body language and his facial expressions what the judge was understanding, what he might have problems with. And in the end, it resulted in the fact that the judge then began to ask me questions himself. And then when that happened, the BP's attorneys just kind of faded because they can't object to what the judge is asking me. So those are some of the lessons I learned. Hopefully, you might not have to do this, but if you do, these are some tips that I can offer you.